If you don't, all right, get kicked out. We're back, Judiciary Committee this Thursday morning, April 9th, and continuing to take testimony on S-193, and the Defender General here to testify next. So over to you, Matt.
Thank you. I'm Matt Valerio, Defender General. This topic and this concept has been, I would say, the bane of my existence ever since Hurricane Irene washed away our forensic facility. And I'm sure it's been a frustration to everybody who used to take advantage of that facility, both from the state and the patients and the advocates and everybody else. And to be honest, we meaning the state, has been struggling with this ever since. Haven't had a legitimate forensic facility. And I have said for years now that the Defender General's office has supported the creation of a forensic hospital for the treatment of individuals involved in the criminal justice system. And the key to this is that the facility must be implemented constitutionally, not that we don't need one, not that, the biggest problem, I think honestly, is, before I even get into any of the details, just looking at it from a 30,000 point view, many states have these, almost all states have these. They are very expensive to do right. All right. And we have not been in a good position to be able to do it right and spend the money we need to do it. To do it right, they have to be secure and they have to be focused on treatment and the physical and mental rehabilitation of the individuals who are subject to the mental illness or condition that puts them there. To be constitutional, they cannot be operated in a manner that is akin to incarceration. These are not jails. These are not places to warehouse people who we think are dangerous. These are places to treat individuals with mental illness to the extent possible and put them in a position where either they can go to trial, or if they are never really going to get to the point where they are competent, if it's a competency issue, to get them to the point where they are no longer a danger to themselves or others in the public, and that their mental health needs are met and managed. If also, similarly, but not the same, for people who are found insane by a court or a jury, they are not a substitute for punishment. They are not supposed to be incarcerated because they are not legally responsible for their actions at the time of the event. Very difficult for people to separate the damage that gets done in some of these cases from the legal requirement that we don't hold people who are mentally ill responsible for their actions in criminal court. Now, that having been said,
Ken has a question.
Yeah.
Good morning, Matt.
Morning.
Were we, was the state successful in handling the guidelines of what you just said before Irene in Waterbury?
In general, yes.
Yeah.
I mean, there's always a particular case where they didn't, but those folks had the representation of counsel, and they were litigated just as they would be in any facility. Everybody who gets put in a place kind of against their will has the right to counsel, and they have rights to get vindicated in the court. But I would say yes.
So, and just
if we could plot Waterbury back where it was, or anywhere, just we're good to go.
so does this bill kind of, or come close to what we had in Waterbury?
Not really.
Not really. Okay. All right.
Almost not at all.
We were doing good.
The The problem is that the destruction of Waterbury at the time kind of tore open old wounds, in a sense. And there are people who, looked at this as an opportunity to do things differently, that's not necessarily a bad thing, but you still have to comply with the law, about what these facilities are supposed to do. And so I just wanted to talk about a few things.
Thank you. Yeah, thank you.
I'm going to direct your attention to page 3 of 16. Sub C line, I believe it's line 5, 5 and 6. I've reviewed, I used to do a lot of these cases right away when I was in private practice, oddly enough. And some of kind of the more high profile ones that have ever been, they've actually created new law in Vermont. It's probably one of the reasons I have the job that I have. And my appellate division, and I agree with them because I wanted them to look at it, is concerned about the constitutionality of 5, 6, and 7, lines 5, 6, and 7, which is sub C.
What page you say?
Page 3. This section seems to violate the Jackson versus Virginia standard that basically says that you can detain somebody who's incompetent in 2 ways, either by traditional civil commitment process, or you can detain them for a duration that bears a reasonable relation and for a reasonable time for that person to restore competence, or to determine that there's no substantial probability that they will attain competence. And this seems to be completely contrary to that because it doesn't focus the attention on that time frame. It doesn't talk about the duration in a manner that is less than open-ended. If someone is incompetent, they ultimately, and they have no likelihood that they're going to be found competent to stand trial in criminal court, the state then has to move to a civil commitment system outside of the criminal justice system, or they have to work quickly to restore their competence, and as part of this, they have to work quickly to determine their competence and whether they will ever become competent. The whole point of the Jackson case was that the criminal justice system would not be a mental health system. What we can't do is that somebody still has the presumption of innocence while they are incompetent, and we can't lock them up indefinitely because they are. So we have to move into, essentially morph into the civil justice system and the civil mental health system. There are a bunch of models that talk about, I'm just going to give you a kind of a collection of statements from various sources. The federal statute 9 USC 4241 says that the feds can only hold somebody securely on a finding of incompetence for 4 months. And that can only be extended if the court finds that they're about to regain competence. The Ninth Circuit says that this was a habeas case because they were held in a facility for competence restoration and didn't get competence restoration services right away. The fact that the services weren't provided within days of detention meant that the court treated the detention not as something for treatment, but for a non-treatment purpose, i.e. a criminal justice purpose. Ninth Circuit also ruled that holding incompetent people in jail for periods of more than 7 days while awaiting a bed in a state hospital was illegal because the jails are not suitable for competent restoration. The state of California has a 2-year maximum for incarcerating someone for a competence restoration. The California Supreme Court held that there was a hard limit, and to allow courts to extend the limit would violate the 14th Amendment of the Constitution. They can move for traditional civil commitment at the 2-year mark, but can't continue competence detention. Florida Supreme Court ruled that someone who doesn't regain competence within 5 years must be released or civilly committed. The bottom line is that there can't be an indefinite hold on somebody to attempt to get them to be restored to competence. And the periods are relatively short. They are not indefinite, and they have to bear a reasonable relationship to what treatment should occur to get them to competence. And it is not something that is relative to the length of what the sentence would be, or the severity of the crime, or any of that. It has to do with treatment modality, right? And that's one of the kind of the flaws of this bill as a whole, is that it doesn't focus on those due process requirements regarding how quickly and what happens next when somebody is found incompetent and not likely to be restored to competence.
Karen.
So thank you for pointing that piece out. And I guess I'm curious that if there was additional language that somehow incorporated civil commitment as an option, would that help to address that?
There are two things in my view that would have to be done. One is that you would have to establish a time frame for competence restoration that is short, not indefinite, and that in the event that competence isn't established during that time frame, that then the state would have to move towards civil commitment. So those are kind of the two stages that seem to be missing, and particularly the time frame is the issue, because the Jackson versus Virginia case is pretty clear, U.S. Supreme Court case, that you can't basically say, well, we're holding them and attempting to return them to competence. People, in the kind of the hard part about mental illness is it doesn't interface really well with the criminal justice system. People wax and wane in their mental illness, and they go into competence, they go out of competence. And it could be a daily thing, it could be a monthly thing, they can be fine for a while, and then depending on how they are, what is going on, we see this somewhat regularly. And it's the nature of mental illness. And so, it's not easy to do, but some courts and the federal law has established, the federal law does the 4-month, which seems short enough. Others say 6 months. Others say, you can't hold somebody in jail. You got to get them into a forensic facility like within 7 days if they're found incompetent, or if there's a question of competence and restoration. So the bottom line is hard guidelines in the criminal law are difficult, but if they're short enough, you don't violate due process. That's that's kind of that's the balance. There's a way to make it amorphous and basically mirror the language of Jackson versus Virginia. However, that can sometimes be, I'd rather see a short, hard deadline as opposed to litigating, that standard.
Do you have the Jackson v. Virginia standard language?
I mean, I kind of quoted it, but
You have the citations for
yeah. And I know Ledge Counsel does too, because I've discussed it with them.
Oh, okay, then that's fine. We'll get that for you.
Yes, I do have all this stuff. Lines 15, 16, 17, same page, really the same issue. again, if competency to stand trial is not restored and cannot be restored, the mental health case must be transferred to the civil commitment arena, and release must be subject to those standards. And in the most general terms, does their mental health continue to make them a threat to themselves or others? A person cannot be held indefinitely to restore competency if that is not achievable within a period of time, reasonable period of time under the Jackson case, and lots of other lower court cases. And it cannot be predicated on the resolution of the criminal case alone, or what the sentence would have been in the criminal case alone. Once you get past a reasonable period of time to restore competence, the criminal case becomes irrelevant, and you have to move to the civil commitment arena.
So I'm just trying to understand all this, because I get that we have to add a civil commitment off ramp, you don't have a time. I guess I don't understand what that all entails. Like, I'm assuming it's another court hearing and doing all of that, but that the person could still be in the forensic facility while that process is being done to determine if a civil commitment, I'm sure it's not just a one day, make the decision.
Right, could be. They
Okay.
could be in a forensic facility during that period of time. Once you get in the civil arena, the time frames and the like change.
Yeah.
And we can't just pluck some, you have to kind of forget about the criminal case once you get into the civil commitment arena. States do these in a lot of different ways. And this is the hard part. And these things are really expensive when you to civilly commit somebody. It involves a lot of experts. Connecticut has a board of civil commitment that is all either medical doctors, psychiatrists, or PhD level psychologists. And they have hearings about civil commitment and release. We've kind of gone down. We did this with sex offenders some number of years ago, where we rejected the civil commitment route for sex offenders, primarily because we knew, like, each case, when this was back during the Douglas administration, and we had that whole rewrite of all the criminal sex laws, and they were talking about $2 million a case just to litigate it. And they're like, we don't want to go that route. And so that's when we did things like indefinite probation, life maximums on all the sex crimes, that kind of stuff, rather than having somebody have a 2 to 10 sentence, and then when they're getting ready to max out, you'd have to go and civilly commit them. They just made everything a life maximum, which.
So are you saying that Vermont doesn't have a robust civil commitment infrastructure?
It has a process, but it doesn't have one that is typically used in these circumstances. And again, it's expensive, and that's, I'm sure that Waterbury, when it was operating, was expensive. Kind of leads me to another issue, and an overlay of this whole thing. It's interesting. It's at the end of the bill. I'm just going to ask the question, which I'm sure everybody else is asking too. Why do we have the Commissioner of Corrections overseeing this? The Commissioner of Corrections is really good at locking people up and observing people on probation. They do a really bad job with medical care and mental health care and treatment and all those sort of things. And we're putting up what has to be constitutionally a treatment facility under supervision of the Department of Corrections. Why is this not under the Department of Mental Health? I don't understand it. Unless what we aren't really doing is treatment and rehabilitation. What we're really doing is isolating these people indefinitely, which the bill suggests is a possibility. That's, I wonder about that.
And it's not just you, Matt, who's brought this up. I think this is probably the fourth or fifth time that I've heard
I
this
would imagine.
in testimony. So not, well, specific to the point that I'm leading up to, but it's probably the fourth or fifth time that it's been alluded to or said explicitly that DOC is not capable of administering the care for these patients / inmates. Because I mean, if they're going to be in the forensic facility, there is the understanding or the reality that they probably had some kind of altercation or criminal history. So again, not specific to you, but what evidence do we have that DOC is not capable of administering this care?
My office has the Prisoners' Rights Office under it, and we are responsible for dealing with all conditions of confinement relative to people in the custody and care of the Commissioner of Corrections. And one of the biggest problems, and I haven't been called in a long time to talk about the medical care and mental health care that is going on in the Department of Corrections. To say that it's marginal is charitable. They have extraordinary difficulty every time they put it out to bid. And I've talked to every Commissioner of Corrections for the last 25 years, where we've had contracted services, and it is, with what they're doing right now, forget about this. It's not done well. And in many instances, I'm not saying the majority, but in many instances, it's done very poorly and negligently. That does not, based on my experience, inspire me with confidence that they would be able to do this.
So again, and I don't mean to, I'm not trying to push back
No,
and
feel free.
have you as the scapegoat for all these, but what I'm hearing again is broad generalities, and I'm looking for something like very specific.
I could come in.
I would love quantitative data, like how many offenses, how many reports are filed, how many instances are there? And again, non-attributed, anonymized anecdotes. I would love.
I could literally come in here with reports this thick.
Bring them in. I would love it. Seriously.
And
because every time I ask for this, not just for you, but of other witnesses, there's never any follow-up. And so that's a personal point of frustration, because I keep asking.
You want me to come?
I'm not being facetious or flippant.
Seriously.
I would love it, because I keep asking for this stuff.
Set a day aside, and I'll be here, and I'll be here for the entire day.
I would love it.
We're the last period of time, and I'm not trying to be flip here, but we're literally stacking up bodies like cordwood coming out of there. And every single one of those we are doing investigations on, and case after case after case.
You're seeing deaths in custody?
Yeah. Like,
again, let's see all this.
I had 4 in the last month, and I'm getting reports back. We get them reviewed by experts. The DOC has its own internal reports, many of which agree with our reports, that indicate that the medical care has been negligently provided. And those are in the deaths. Over a third of the work that the Prisoners' Rights Office does now is trying to get people the medical care that they need. They run out of medicine that is absolutely essential, like antibiotics, insulin. People who are on MAT are not consistently getting their medication. So, these are medicines that you have to take over a long period of time.
Yeah.
So when that doesn't happen, you end up with severe problems. DOC will legitimately say that we have a difficult population that comes in with a lot of medical problems. They do. But what they have also is a system that is not robust enough to respond to. When they advertise for a medical contractor and they get one applicant, they're pretty well stuck as to what they're going to do when they have one person who's willing to do the work. And the one person is the person they fired for one company. It's the person they fired 2 companies ago, but now they've come back because the one that they just fired. And, it's a very small number of companies that do this work. And we are in a bad cycle with that. And I've talked to all of the commissioners about it. You know, I've said many times, I have incredible respect and admiration for the work Nick Dimmel when he was here. Andy Polito, Lisa Menard, they all tell me the same thing. I don't know what to do. I don't know what the answer is. Because they have very limited options. Now, I'm not ascribing blame. I'm just telling you what's
No, I
happening.
understand that.
And so,
And again, I'm not trying to make you the scapegoat of this, but if we keep hearing these very broad generalizations, and again, it's not just on this topic, but in this committee room in general,
Mhm.
we keep hearing these things and there's never any facts to back it up. So it sounds like you are in possession of the facts. And I would love to just sit down, whether it's you and I, or if there's a smaller group of us that sit down with you, I think that'd be very productive.
yeah, the statute says that we are responsible for investigating any serious incident or death or hospitalization that occurs as a result thereof for 48 hours or more in the Department of Corrections. We also are responsible for all conditions of confinement issues, and that includes medical care. And so I have reports going back many years regarding that. There are two ways that we handle it. Primarily, I go to the Commissioner of Corrections and say, problem, 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 problem. And they go, uh-huh. And then somebody files lawsuits, and that's how they're resolved. The other thing that it says to do is to report in an anonymous way to the Joint Justice Oversight Committee, which I have not been called before in many years.
Who's on that?
A selection of people from here, from House Corrections Institutions, Senate, Judiciary.
There's members of it in here.
Oh, yeah.
So I think last year, and the year before, there was a lot of health well path was in on more than one occasion, talking about the service. And they also were considering whether to bring it in-house. And that was before. I don't remember if it was last year or the year before.
Yeah, that's the way it used to be many, many years ago. It's kind of interesting that there's a whole conundrum here that DOC has. I don't envy them trying to solve this problem. If I were Commissioner of Corrections, back in the day, they had state employees providing medical care. When they decided to go to contractors as opposed to state employees, you brought contract administration in. They might have a medical director who for the contractor, and they ended up hiring all the people who used to work for the state to administer the care for the contractor. So, you know, to quote an old song, you know, beat the new boss, same as the old boss. But the bottom line was it didn't change. And here's the other thing that is very interesting. While people do cycle in and out and never come back, by and large, when you get a new contractor in, they do the same thing. They hire the people who used to work for the old contractor who are willing to do the work for the new contractor. Most people, I'm not saying all, who provide medical care in correctional facilities didn't go to nursing school or medical school to say, I want to provide medical care in correctional facilities. They had something else in mind, but ended up doing this. And all kinds of reasons. Sometimes, and I don't even want to go into all the reasons, but the bottom line is it is difficult, just like it is difficult to hire corrections officers. It's difficult to hire medical staff, nursing and the like, to do that work. And so it's a conundrum. It's really tough. And so all I'm saying is, do I have reason to believe that it might be difficult for the Department of Corrections to implement a forensic facility under their umbrella when that is not their primary mission? Yeah, I have reason to believe that. And it's based on experience, not just the label that somebody's the Commissioner of Corrections. I guarantee you that the Commissioner of Mental Health knows more about that area than John Murad does.
Tom and then Tom.
I was just curious if one facility stood out more than any of the others.
The only thing I can say is that the primary infirmary is in Springfield. So it'd be, yeah, so the worst
That's why I asked.
cases end up there. But it's kind of unfair to say, oh, it's Springfield, because it's not really Springfield.
No, I
And
know
it's not really,
Spring.
it's
transferred there.
yeah, they get, when they get in a bad situation, they they end up, medically, they end up in Springfield. Do people die in other facilities? Yes. Is medical care spotty in other facilities? Yeah. But the more severe cases are in Springfield. Yeah. So, women's facility is, in Chittenden County, and that's a little bit of a different situation too, because, first of all, there's way less of them. But it's also, of the women who fall into this, it's obviously all going to be in that facility. So there are ways it gets segregated out, but I don't know that it's worthwhile really to say, oh, it's Springfield, because that's the magnet,
You think the women's facility, they're getting more help because the hospital is right in close proximity to it?
No, I really don't. In Springfield, they use Dartmouth, which is pretty close. Not as close as Burlington, but this is a very, very difficult issue that doesn't get a lot of airtime. So anyway, that's my concern about under that umbrella. I don't know why the Department of Mental Health would not have this facility.
You talked about Waterbury earlier. I remember writing. Your opinion on it was ran fairly well. Maybe not perfect, nothing perfect.
Nothing's perfect.
So was Waterbury Department of Mental Health or Corrections?
Mental health.
I don't know why this was Corrections. Do you know why it went to Corrections? Other than maybe somebody was concerned about the security end of it, that's what goes through my mind.
Yeah, and if that is the concern, then what you're looking at is effect akin to a correctional center as opposed to a Kendall hospital. You can have, and they did run in Waterbury, a secure mental health facility. All under EHS, as DOC is also. But, maybe they're changing. I hate to speculate. I have all kinds of, I hate to speculate.
Right.
It does concern me though, if, let me just think of it this way. Pretend I'm an advocate, I'm not Defender General, I'm an advocate on the outside, working for disability rights or, one of those groups. And I say, hey, this isn't constitutional. This is a jail. What's one of the first things I'm going to point to? But it's supervised by the Commissioner of Corrections. And then we'll go down the rest of the list as to, we want to hold people indefinitely. We want to, we're holding people based upon the duration of their sentence as opposed to their mental health needs. Like you start to check the boxes in the bill as to me proving that this is actually a correctional center and not a mental health treatment facility, which is what it needs to be. So I'm pointing out these issues to try to help you. And whatever happens, happens. And then the result is going to be what it is.
So
You want me to?
say if it didn't change, it's gonna be under Corrections.
Yeah.
And I think from what I just got from what you said is that the guts of the bill lean more toward corrections than it does toward mental health.
That's what it looks like. It's about, hey, I get it. This is about public safety. This is not about rehabilitation of the mentally ill. That's what this bill is about. And, if I am, the public might look at it and say, good, that's exactly what we want. I'm just trying to tell you to follow the law. And that's not what it's supposed to be. So.
Angela and Denise.
On that follow the law thing, it's our my understanding that the Department of Mental Health statutorily cannot consider public safety? Do I have that wrong?
Well, they still have to review the issue. It's not public safety. They have to review, is this person a danger to themselves or others? Are they a danger to the public? Can we like if somebody is hospitalized and they are seeking release, can the department create conditions of release on an order of non-hospitalization that are sufficient to ensure the safety of the public and the safety of the individual? So if you take your medication, if you live where you're with supports, if you maybe have a job, if you actually have housing, if these things are complied with, their opinion from a medical standpoint is that this person is fit for release because they stabilize them on the inside, whether it's medication or other treatment, whatever it is, and then they are fit for release. Here's the hole in the system. I've brought this up many times. If you are, and I'm going to make it akin to corrections, right? When you are released on furlough or you are paroled, someone has made a determination subject to conditions that this person is fit for being in the public. We do that same thing in the Department of Mental Health. When you're released on the corrections side, there are probation officers and there are probation parole officers who check up on you, who make sure you're doing the right things. And if they don't, they violate you and drag you back in. That doesn't exist on the mental health side. What do? They rely on law enforcement when the people go off the rails to arrest them again and start the process all over again. I've suggested for over 5 years now that the Department of Mental Health needs a unit that is akin to probation, but not probation, staffed with mental health social workers who affirmatively, which doesn't happen now, affirmatively checks in on the people who are subject to orders of non-hospitalization to ensure that they are taking their medication, that they have housing, that they are not decompensating. And if they are violating those conditions, the Department of Mental Health could then file a motion with the court to hospitalize that person or to develop other conditions that would ensure that they are safe and not decompensating. That does not exist today.
Right, and this bill proposes that DOC would be responsible even for that.
Right. That is not the worst part of the bill. The problem is, and I didn't even, I was going to say when I got to that point, that we're getting there. This is what should be happening, but it shouldn't be probation and parole officers doing it. It should be people trained in mental health, social workers with mental health training who are looking in on mental health patients. It's not just a matter of, are you compliant? The question is, are you decompensating? So if you're not taking your medicine, we understand that might lead you to decompensate. If we see you, even if you are taking your medicine, not doing well, then we have to address that. Change your medicine, increase your medicine. Maybe we have to hospitalize you again for a period of time. But they're going to look at it from a medical, psychological needs standpoint, not about what corrections officers typically look at, which is compliance as opposed to mental health. And they are distinctly different issues. And so, again, I don't necessarily trust that the Department of Corrections is going to look at it through the right lens when they're dealing with the mentally ill. All they will see is somebody who is not complying, which leads you back to the issue of, are we doing treatment here or are we doing something else? In any event. Happy to answer any of the questions. I wanted to,
Ian,
Just two questions. One, did you raise these issues on the Senate side on this bill?
yes. And actually the Senate took out a bunch of stuff that was significantly more egregious than what you see. And I'm not, by the way, this is 50% better.
Oh.
I don't want to say 100% because if it was 100%, probably I would have wrote it. But it's 50% better than what it was bill as introduced. Because what I would do is write it strictly to just comply with the law. I wouldn't have any particular policy reason to do anything. Honestly, our current law as it exists is not bad. We just don't have the means. We don't have the facility anymore to comply with it. And so now we're creating a thing because we aren't going to be building anything here. We're dedicating a wing of some correctional facility to house these folks. Again, it's very, washing away Waterbury was devastating. Devastating in cost and, it's hard to even explain.
And that was my other question, was just as a newbie legislator who also wasn't really involved in my other work before Irene. So basically, the reason we're not just doing what we did before Irene is because we don't have the money to basically build a new facility that would do the same thing that it did before if it was working fairly well. I understand that there are issues with any institution.
I would ask somebody from administration, but that's my observation. I think that's right. And even if we went back to the other thing, I still think this suggestion, I keep bringing it up about the social work, people who are akin to probation officers, but looking at it through a different lens. Waterbury could have benefited by that structure. The other thing is, this is not like probation and parole. We don't have thousands of people. This is a small group of people. This is not big. You don't have to have, I don't know how many probation officers there are. I'm guessing it's more than 100. You wouldn't have to do that. You might need 6. So in any event, you want me to talk more about the bill?
yeah, that would be great.
I'm happy to talk about policy and history and all of that, but
No, it's helpful.
let me, maybe I'm reading this wrong. Page 4 of 16, lines 9, 10, 11. This is where you have the hearing. The commissioner shall notify the court where the person was committed upon return of the person to the forensic facility. And upon readmission, the court shall hold a hearing at which the state's attorney shall have a burden of proving by clear and convincing evidence that the person is not competent.
Yeah,
Does it mean-
we have flagged that as
Okay.
backwards. And
Yeah, I'm figuring, I'm kind of a few people down the road here, but I think all you got to do is take out the not. But sometimes I read things wrong, and if I was wrong, I would just wish someone would tell me. But yeah, I could have read it wrong. Like sometimes there's a double negative in there or something where it's not incompetent or something. And
Is that your frankness of humor?
Yeah.
Or something.
well, I don't know. I had a little note on section 2, page 5, lines 15, 16, and 17.
What page did you say you're on?
Page 5, lines 15 through 17, or 15 through 18. I'm not, just a little odd. I don't really know. See, one of the things about these mental health cases, and this is where when we are handling these, sometimes from a client's point of view, I'd rather just be convicted of a misdemeanor than go through all of this hoo-ha with the Department of Mental Health and be declared incompetent and all of that stuff. Because I could be held way longer, on a misdemeanor for being incompetent than I could be if I just ate a criminal charge and accepted a fine, or even was put on probation, or even served 3 days in jail. People don't serve a lot of time on misdemeanors, if at all. And so I just wanted to bring up that if you create an egregious situation for people with relatively minor crimes, they're just going to eat convictions, notwithstanding their mental health situation. And they'll just stand there. Do you agree the state could have proved its case beyond a reasonable doubt? Do you not contest the state's case? Yeah. Okay. We'll sentence you to time served and $100 fine. Thank you very much. And now the mental health person is walking out the door. Seen this time and time and time again. Happens all the time.
So Ken has a question on that.
Or you just answered it. It happens very frequently.
Yeah, I mean, I can't say all the time. It's not every day, but of these types of cases, and a lot of the cases where you get with the people who have these mental health problems, it's the high profile ones are the murders and sex cases and that kind of stuff. The vast majority of them are this kind of thing, where they're causing problems on Church Street, and that is a totally different animal.
Thank you.
So what did I have to say here? It's interesting. I do these things and I put on my computer, I put my notes in the side of the PDF and it looks great. And then I print it out. I can't read the freaking things. They're so, it comes out like 1/10 the size of what I had. And I mean, these are only
glasses.
These are only 1.0s, but they do work. It's just like, it's frustrating because I can
Not very well.
Page 6.
You want to borrow some tools?
I'm good. These work fine, but it's I have good eyes. So I take them off, then I can't see. I put them on. Page 6 and lines 5 and 6. This to me kind of misconstrues or conflates the issue of sanity versus competency, where a person's charged with an offense punishable by a life sentence and is found not guilty by reason of insanity at the time of the offense charged, but oddly written, shall be committed to the forensic facility. Remember, an insanity defense is like a Polaroid. You know what a Polaroid is?
A camera?
Yeah, the snapshot. It's a moment in time where somebody maybe had a psychotic break, maybe had some problem with whatever went on. Your trial that's going to go on may take place 2 years later, and the person may be fully competent, not suffering from a mental illness at all, but raised as a defense in their trial that they were insane at the time of the event 2 years ago. I'm wondering why the default, without any proof of their current mental state, is that somebody who is not guilty by reason of insanity for an incident that snapshot in time that took place remote to the trial or the hearing, why the default is that they go to the facility. If the reason is because of the alleged offense, that's a constitutional issue. If the reason is they are continuing to suffer from a major mental illness, that is legitimate, because now you're talking about the civil commitment of somebody with a major mental illness in the present, who may, and we can prove this by evidence of what went on 2 years earlier at the crime, but that's part of the evidence. I just wonder, I wonder why the default is that, as opposed to, what you end up with. And maybe it's a bit semantic, because it does provide a process later, which is akin to civil commitment, but with kind of different standards.
It's a question about that.
Yeah, go ahead.
I wonder, Matt, if the default was put, if that was the default because the hearing, in the language as it's written, hearing happens within 48 hours. Maybe the default was like, yeah, that's not, so it felt
Yeah.
safe enough doing.
Yeah, close enough.
Default.
And I just raised the issue because the next question comes to that next section where it says section 2, prior to the date of the hearing, the court shall order a forensic risk assessment, and then includes various things in it that are not the same things as you would get in a civil commitment proceeding.
And I
but
imagine
look-
it's not gonna happen in 48 hours.
But look very similar to what you would do in a pre-sentence investigation. And so what I think sub 2 should not say a forensic risk assessment. What it should say is a forensic mental health assessment.
What do you think about the 48 hours? We've heard testimony that it should be 60 days. We've heard 10 days.
Well, I think if your default is going to be that you're going to immediately put somebody in a forensic facility, if as designed, I would feel better if they said, look, you're going to be subject to the custody of the Commissioner of Mental Health in a hospital for 48 hours pending pending this evaluation. And we have people on staff available to do this pretty much immediately, because these don't come up very often. I've told you before, maybe very recently, that nobody in the collective memory of the defense bar can remember any jury in the last 50, 60 years that came back with a verdict of not guilty by reason of insanity. These are usually reached when the court order evaluation comes back, this person was insane at the time. The defense will kind of rely on that. The state will say, I want to have another evaluation. So they do, and their evaluation comes back and says the person was insane at the time. And the sides say, well, I guess the person was insane at the time. And now we go to the judge and present the two reports, and the judge says the person was insane at the time. It's effectively a stipulated or agreed to situation. It's not, and there have been times when a judge alone has made that decision because you waive a jury on the issue, and you present the evidence, the court makes a decision. But a jury verdict, could it happen? Yes. And every year this sort of comes up, and I will survey. I'll talk to Richard Rubin, who's been a lawyer for 60 years. He said, no, never seen one. Talk to old judges who I knew. No, never seen one. Nobody's ever seen a jury come back, because usually they get scared to death. I mean, I don't blame them. I did a very serious case years ago, and tried what I thought was an excellent insanity defense. And the case lasted 10 days. It was a kidnapping attempted murder case. Oh, and all right, we got 10 days of evidence. Jury's out. They've been instructed. I'm going to get in my car. I'm going to drive through the drive-through at Burger King and get myself some lunch to bring back to the court and sit and wait around, and it might take a day or two even before they come back with a verdict. I'm literally sitting at the drive-through and then my phone rings and they're like, they got a verdict. Like, what? Well, yeah, it was pretty obvious mental, insanity case. Come back, like guilty on it. And I'm like, oh well, that didn't work. So probably 2 weeks later, I'm walking down the street and this guy starts yelling at me from across the street. And I'm like, that, it's kind of doing what I do that gets a little unnerving. So I put my hand on my gun. No, I didn't. So the guy runs across the street. And I noticed I was a lot bigger than he was, so I wasn't that worried. And he said, Matt. I'm like, yes. He's like, you probably don't recognize me. I was on that jury. And he's like, oh, yeah. He says, I wanted to tell you, you did a really good job with that case. I'm like, I didn't feel that good because you didn't have a chance to go to the bathroom before you had a verdict. Yeah, that guy was crazy. We were never letting him out. And I'm like, all right. So what it said to me was I scared the hell out of them by showing how mentally ill the guy was. I mean, that is the issue with these kinds of cases and the general public. And it's why you don't have jury verdicts that say, unless it's disorderly conduct or something, but nobody can even tell me one of those because usually the state's attorney says, yeah, we're they get diverted or whatever. So in the event that this ever occurs, this is going to be pretty well orchestrated, is what I'm saying. It's not going to be like, oh, wow, a jury verdict just came back of not guilty. And it wouldn't say not guilty by reason of insanity. It would say not guilty. That'd be the verdict. The insanity defense is an affirmative defense that we prove it. The jury doesn't say insane. It just says not guilty. But when you're not guilty, you get to walk out the door. That isn't how these happen. What ends up happening is they're kind of orchestrated. Everybody knows the person was insane at the time. And a lot of this stuff, like the evaluations and the like, would have been done. Everything would have been prepped. So this 48-hour period doesn't really bother me. If people don't this is, to me, if you extend it, it's because somebody doesn't like the result and they're looking for another opinion to give a different result. That's okay. But the issue is really, to me, the timeliness, like the practicality of how this works. If we have somebody on staff who's able to do these evaluations, then it's okay. Now, these are not, in my view, going to be the same as the competency evaluations we do by teledoc and on computers, and they take months to set up. And, it's going to be something different when you're seeking to hospitalize somebody.
And is this just a quick follow-up? I didn't realize, is this section pertaining only to jury verdicts?
It isn't, but
Okay.
it's both.
Right, so it wouldn't be as infrequent as never.
Well, you'd hope.
Yeah, okay, just making sure.
And all I'm saying is, you asked me about, is the 48 hours too short, too long, too whatever? To me, because they are not jury verdicts, which you don't know what the jury's going to do, these are things that everybody pretty much knows exactly what's going to happen before you ever get to this point, because it's something the state knows, the defender knows, the judge knows. You've been working with this for quite some time. If you get to not guilty by reason of insanity, because the judge has made that determination, everybody knows what's going on. And that 48 hours shouldn't really be a problem.
Okay.
But, and it also does comply with kind of the time limits that are set in, it's one of the shorter ones. But You know, I don't think that it's not undoable.
Yeah.
It's not undoable. It is, I can see why people might want to make it longer, to be fair. You know, the forensic risk assessment part is I want to get away from the idea that we are just judging risk. What you need to be doing is judging what is the mental state of this person? What do we need to do, if anything, to make sure that they are not dangerous, that they are not suffering from mental illness. And the first stage really has to be, are you currently suffering from a mental illness? Not were you charged with a crime that is punishable by life sentence. It's, are you suffering from a mental illness? And then you go through the other factors about dangerousness. On page 7, this kind of just reads if you get poll other shows talking about page 7, lines 16, 17, 18. I know it's not actually the commissioner who is making the decision about what are the least restrictive conditions. Is there adequate care in a forensic facility? But shouldn't it be like the Department of Mental Health again? If the Commissioner of Corrections doesn't agree with the recommendations of the doctor, would the commissioner in his discretion say there are no conditions that would make this person safe? That would be contrary to civil commitment law, contrary to the due process required to hold somebody who has been determined to be incompetent or insane. Again, it's just, you don't want me fixing your car. And I have a doctorate, but you don't want me fixing your car. Commissioner of Corrections probably, I think, can do probably reasonably good job with corrections. I don't know about this stuff.
Yeah, thanks.
So Matt, I just have a question. If an impacted individual is not diagnosed with mental illness, would EMH still take them?
No.
Right. So I mean, that's kind of where my concern is that, and again, I'm looking forward to seeing all the facts and the data to back up, to substantiate what you're telling us about DOC and the concerns there. But is the quality of care argument a red herring to move this away from DOC to DMH, when DMH, to me, doesn't seem that they have the resources or the ability to implement this? So I feel like it de facto has to be DOC.
Well, they did it for decades. They did it, and they're doing it now to some degree. I mean, what we don't have is a facility. You know, they staffed Waterbury. They did it then. Can't we do it? It's a small number of people. This is where, is this more about public safety than it is about mental health? Once you get,
I think it's equal parts public.
well,
safety.
once you get to the point where you are in the mental health arena, you are subject to different constitutional requirements. And
But to my point, if mental health is not, if they're not diagnosed with a mental illness, and this is squarely in the realm of public safety, that answers the question of why this has to be DOC.
well, it also is the reason, if they were not competent to stand trial, it has to be mental illness. Right? Yes.
We can have the debate. Yeah.
No, they have to be. If you are competent to stand trial, you can even have a mental illness and be competent to stand trial. But if you are actually deemed incompetent to stand trial, must have a major mental illness, and you must not be able to understand the proceedings or participate in the proceedings before you. So that issue of whether you are mentally ill is period.
But I think the issue of competency, and that was a conversation that.
That's what we're mostly dealing with.
Well, and that's exactly right. And that was a conversation that we're having before, in between sessions, is what it really gets to the crux of the question of what is incompetence. And how is that derived? How do we define it?
I can tell you. The laws tell you very easily.
But I think you're representing that viewpoint. I think there are probably
It's not a viewpoint.
contrarian viewpoints to that.
It's not a viewpoint. I'm just telling you what the law is.
But what would the administration say? Or what would public safety say?
Well, public safety is concerned about public safety. I'm concerned about following the law. And they're two different things sometimes, If you're not competent to stand trial, you have a major mental illness, you're either not able to understand the proceedings that you are participating in, you are unable to participate or work with your lawyer, you don't understand the role of the various individuals, and as a result, you're not subject to the jurisdiction of the criminal court because of your mental disease or defect, your mental illness. Okay?
Some point of
So-
piece.
I guess the way we've been looking at that, just to clarify, is it isn't necessary, it depends on how you're defining mental illness. It could be a developmental or behavioral.
Well, that's why
disability. It's like Dale.
That's where it's mental disease or defect.
Right.
So
Or it could be a traumatic brain injury. It
Right.
could be
Yeah.
dementia.
Could be.
It could be any number of things which I say may not fit in DMH, but may fit in Dale.
Right.
So, right. So I just want to clarify that.
That's fine. The bottom line is you can't understand or participate in a criminal proceeding against you. That's the key. So that is not, and that person can be incredibly dangerous or not. That's the question. You don't jump from one to the next. That's when you get to that next stage of the analysis. Okay. And I don't, there is a process, obviously, for commitment of individuals who don't fit under mental health. They fit under the Dale umbrella. So you have organic brain dysfunction or a traumatic brain injury or developmental disability or whatever. They fit into a different category, but the result is the same. And so those people still have to be treated, and they have to be restrained or detained in the least restrictive environment, subject to conditions that would make sure that they are not a danger to the public. I don't know how that falls under Department of Corrections.
But I guess too, in terms of, the bill is currently written. The bill is currently written does have a clinical care coordinator built in. So I mean, these inmates will be receiving care and treatment.
The Department of Corrections currently has a clinical care coordinator and medical coordinator to do what it's doing now.
Right. And so we're bolstering those resources. Right. I mean, that's how.
Maybe. All I'm telling you is our experience is that it is not something they do well now.
Which is why we're allocating more resources to help them. I think that's kind of where I feel like the disconnect is and where I kind of take issue with some of it.
All right, where are the resources?
The additional clinical care coordinator,
One person?
better than the one that they have. I mean, we're talking about there's service gaps across the government map. And so I think if we're willing to allocate additional resources in any way, that's a win.
Why don't we give the clinical care coordinator to the Department of Mental Health then?
Because they don't have the ability to implement this. And that's very clear.
I'm not sure about that.
We're going to diverge on that point. I mean, I'm squarely in the belief that this has to be DOC, and I know that you disagree with that.
Mhm. Well, and you've got the vote. So
And
exercise it as
that's the
appropriate.
ball game, right?
Yeah. Yeah, that's what I'm talking about. Page 9 of 16 is one of, and I wanted to point out, lines 15 to 18 kind of incorporates the, oh, wait a second, I'm sorry. Page 8 at the bottom. one of the things I was talking about in the Senate, this is lines 2021 and goes over onto the next page. It's unclear to me here, page 8, line 2021. So if the reviewing court finds by clear and convincing evidence that the person is no longer suffering from a qualifying condition, that's being illness or defect, whatever. Who has the burden of proof? There's nothing in the bill that I could see. This was an issue that I raised on the other side. And typically the person who seeks to hold somebody has the burden of proving that that person is a danger to themselves or others. This doesn't really, this is just silent about it. It should be clarified. As I was talking about before, page 9, I like the idea of affirmative monitoring and of orders that where people are released. Again, apparently there might be some disagreement over whether it should be the Department of Corrections that is doing the monitoring. We should, in my view, that is something that is perfectly suited to somebody with a mental health background who's going to look at it through that lens as opposed to a compliance lens that is typical of probation and parole officer. And I have already talked about on page 11 the commissioner being in charge and whether I believe a clinical director in DOC is the right way to go. You know what I feel about that. The page 12 on line 16, 17 says records shall be made available to the parties in the underlying criminal case upon request. And these are records related to the person in the forensic facility. That's fine. However, by the time they're in a facility, there may not be a criminal case. They're also, I think what you need to do is really clarify that legal aid comes in after there's a finding of incompetence or a finding of insanity. And it should be both. It's really counsel, but parties. I didn't want it to, we run into this thing right now that is a conundrum for the defenders in that a case ends up going the mental health route, order of hospitalization or non-hospitalization or the like. Yet, and we're supposed to be off the case at that point, yet we keep getting dragged into cases for sometimes years when there is no case. And it's fine to kind of send us records, but you know, my lawyers get a hold of me and say, why am I getting summoned into court on this case that I've had nothing to do with for 2 years? The legal aid is handling the case. And they have it in a mental health arena, dealing with it post finding of incompetence, vast majority of the time. It should be that, I think that should be clarified. Bottom line is, if you want to send records to the to defense counsel if the case remains kind of stayed or pending, usually it's the bigger cases, murder cases or something serious, that's fine. Make sure that legal aid gets a copy. I wish there were clarification, and I think I had suggested this on both sides. I may have even suggested it as like a separate bill, that the public defender should be allowed to withdraw if the case is no longer pending and in criminal court. Kind of a separate issue and more of a convenience thing for them. They have plenty of other things to do. But I would just want to clarify that lawyers of record, let's just put it that way. I don't really have any other comments on rulemaking and all the other stuff, or when it takes effect and reports and all that stuff. I was more concerned about the concept that that we do it if, that again, I support a forensics facility. I support that it be done constitutionally. I support that if people are in this position, they be treated as they should be, which is as a person who is sick and in need of treatment. And that we not blur the lines between incarcerating somebody and hospitalizing somebody.
Well, really appreciate your testimony, Matt. Lots of things for us to continue to look at. So I understand that one of the bills that's on the floor this afternoon, not ours, is going to be postponed. So it's not going to be as long of a floor. So we'll be back here at 2:00 or immediately after the floor is later. I think that's right. Yeah. And we'll hear from Karen Barber from DMH on 193. So we are going to 2:00 or immediately after the floor, whatever.